thus becomes, having listened to Mr. Masengeli, is the court satisfied that he is sincerely and genuinely apologetic about the circumstances that led to his conviction and sentence for contempt of court? In explanation, to exonerate himself, Mr. Masengeli stated on oath, giving an account in which he explained why he could not personally attend court on the 26th of August 2024, 29th of August 2024, 3rd of September 2024, 5th of September 2024, and 9th September 2024, including the date of his sentence on the 13th of September 2024. He gave reasons that he was torn between national security duties and his obligation to attend court. He did not, however, explain why he could not commit to attend court on the day he had actually indicated he would attend, that is on 9th of September 2024. He was cross-examined by advocates for the petitioners, and my observation is that his answers appeared genuine. He was calm and polite. To crown it all, he pleaded with the court, stating that if he had been wrong or made an error of judgment in prioritizing other exigencies of duty over the court summons, he sought forgiveness and mercy from the court. He stated as follows, and I quote, "I want to apologize to this court and the judiciary for the events that transpired leading to orders of contempt of court. I respect you and the good work you do to uphold the law. As a police officer, it is my duty to enforce court orders and ensure court orders are obeyed. I pray the court accepts my apology, vacates the conviction and sentence. I so pray." End of quote. This court is convinced that Mr. Masengeli regrets and is genuinely remorseful for the situation he finds himself in. It is not the intention of this court to punish a genuinely repentant man who has acknowledged his mistakes and offered an apology. His conduct today has restored the dignity of the court and the due administration of justice by attending court and explaining the difficulties that caused him not to comply and offering an apology for any of errors of judgment he might have made. His undertaking to always obey and enforce the orders of the court came out strongly. The court is fully satisfied that the purging process has been infused in his mind, or in the mind of the contemner, Mr. Masengeli, the obligation to respect and uphold the rule of law and the due administration of justice. The supremacy of the law has equally been vindicated. To this end, I must arrive to the determination that Mr. Masengeli, through this purging process, has purged his guilt for the contempt of court, and thus both the conviction and sentence passed are set aside. I must, however, not end this deliberation without speaking on the need for all to respect and uphold the independence of the judiciary. It is a judiciary that guarantees adherence to the rule of law. Every Kenyan who means well for this country must fight for the independence of the judiciary so that judges can be allowed to make decisions based purely on law and the facts without the fear of reprisals, interference, pressure or threats, whether direct or indirect. That is the cornerstone of democracy. It should be known to all that the independence of the judiciary is not for the judges per se, but for the benefit of the public at large. It leaves judges with the discretion to make fair and even-handed decisions meant to uphold the rule of law. Judges must never and will never hold. Judges will always hold government organs to account for adherence to the Constitution and the law, and it is the primary duty of the state to ensure judicial independence is protected. I am happy to note from the LSK that the 3 Kenyans, the subject of this petition, have been found. Having said so, and considering everything else, I I am making my decision to recuse myself from the further proceedings of this case for personal reasons. I will thus be directing that this file be placed before the presiding judge for allocation to another judge. That's all.
My Lord, to state that we're very grateful for your patience.